Opening debate. On la prise du débat, the honourable member for Ottawa West Nepean.
Thank you very much, Mr. Speaker. And I rise today in support of Bill C-223, the Keeping Children Safe Act, introduced by my friend and colleague, the member for Hamilton Mountain. I want to begin by acknowledging the courage of the many survivors, advocates, legal experts, and organizations who have spent years bringing these issues forward, often at great personal cost. I want to acknowledge the work of the hundreds of organizations across Canada who have called for this reform. This is an important bill that will protect children and families as they navigate through the court system. The bill's central purpose is protection for the survivors of intimate partner violence and their children as they go through the already complex and emotional process of separation and divorce. Ce projet de loi nous permet de croire les survivants et d'éviter qu'ils ne soient revictimisés au cours du processus judiciaire. At its core, this bill asks whether we are truly centering the best interests of the child, or are we allowing outdated assumptions and systemic blind spots to put children at risk? Mr. Speaker, the answer matters because family law decisions are not abstract. In fact, they shape children's daily lives, determine who they live with, who they see, and whether they grow up safe. Le projet de loi C-223 met l'intérêt supérieur de l'enfant au cœur des décisions. Il précise qu'il n'existe aucune présomption de garde partagée et que les décisions doivent être basées sur la sécurité, le bien-être et la réalité vécue de l'enfant. This bill requires legal advisors to screen for family violence, including coercive control. This bill strengthens the court's ability to assess the impact of coercive control on the parent-child relationship. This is critical because coercive control is not always visible in bruises or police reports, but its effect on children are profound and long-lasting. This bill ensures that children's views and preferences are meaningfully considered and that they are not automatically dismissed as the product of manipulation. Bill C-223 gives children the opportunity to be heard in an age-appropriate way with proper safeguards, and it makes safety paramount to consideration in custody decisions. Finally, Bill C-223 prevents courts from issuing orders that re-traumatize children, including forced reunification therapies or sudden reversals of primary residence in the absence of evidence that such measures are safe or necessary. En 2024, Statistique Canada a rapporté qu'il n'y avait que 25 000 enfants et jeunes victimes de violences familiales déclarés à la police. Nous savons que ces chiffres racontent qu'une partie de l'histoire de nombreux cas de violence familiale ne sont jamais signalés. Children who have experienced or witnessed family violence carry trauma that shapes their development, their sense of security, and their ability to form healthy relationships. When our family courts fail to take their fears seriously, when courts dismiss their disclosures as manipulation, when children are forced into the care of parents who have harmed them or harmed the other parent, we compound that trauma. We teach them that their voices don't matter, that adults won't protect them, that the system designed to serve their best interests has in fact failed them. When I served on the Status of Women Committee, we studied coercive control. We heard testimony from survivors, lawyers, psychologists, and frontline workers. Again and again, we heard how violence does not end when a relationship ends. In fact, in many cases, it intensifies through the courts, through custody disputes, and through the manipulation of legal processes themselves. We heard how coercive control operates not only through physical violence, but through fear, surveillance, intimidation, and the erosion of autonomy. And we heard repeatedly how children are drawn into that control, used as leverage, silenced, or forced into situations that are unsafe in the name of parental rights. During committee testimony, we heard heart-wrenching stories about the harm that forced reunification had on children. For example, we heard from a 17-year-old girl who told us she was ordered by the court to go to a reunification camp in New York after her father claimed parental alienation. She told us it felt like she had been judicially trafficked. Judicially trafficked. Those are her words. Among other things, she and her younger brother were told that their negative memories of their father were not real. They were forced to smile in photos and tell their father that they loved him. And they were forced to show physical affection toward their father under threat that if they didn't, they wouldn't be allowed to see their mother. When this witness was 16, she ran away to try to go to her mom's house, and her father had the police bring her back. She was ultimately under a no-contact order with her mother for over 500 days. Sadly, this is not an isolated incident. We heard of a young woman just today who at age 15 was forced into the custody of her father who sexually abused her. Children told us over and over again that they felt that they had no voice, that nobody believed them, that there was nobody to talk to, especially when their disclosures of abuse, when they finally did tell someone, those disclosures were repeated to the abusive parent who used it to further intimidate and victimize them. Under this bill, children would be able to tell their story confidentially to the court without fear. This bill treats children as people with agency, not as property to be divided. Trop souvent, les décisions sont encore influencées par des mythes et des stéréotypes. Que la coparentalité serait toujours la meilleure solution. Que les enfants qui refusent le contact auraient été manipulés ou qu'un parent, souvent la mère, qui soulève des enjeux de sécurité serait jugé déraisonnable ou non coopératif. Research shows that mothers are twice as likely as fathers to face allegations of parental alienation, even in cases where violence is documented. Protective actions taken to keep a child safe are reframed as hostility. Fear is reframed as non-cooperation, and children's voices are too often dismissed on the assumption that they cannot be trusted. This bill does not remove discretion from judges. It actually guides it with evidence. Bill C-223 does not diminish the importance of parental relationships. In fact, it recognizes that a relationship that is unsafe is not a relationship in the best interests of the child. Le Comité de la Condition féminine a clairement entendu que si les tribunaux ne comprennent pas le contrôle coercitif, ils risquent de le reproduire. S'ils mettent l'égalité formelle avant la sécurité réelle, ils mettent les enfants en danger. Mr. Speaker, Canada has committed internationally to protecting women and children from violence. The Keeping Children Safe Act builds on that commitment by aligning our domestic framework with evidence-based best practices and international human rights obligations. We can't meet those commitments if our laws remain out of step with what we know. Bill C-223 asks us to listen to children, to take violence seriously, even when it is subtle, and to ensure that the justice system does not become another tool of harm. Ce projet de loi vise à faire en sorte que si des familles vivent de la violence, elles ne soient pas revictimisées par le système même qui devrait les protéger. For these reasons, Mr. Speaker, I am proud to support the Keeping Children Safe Act, and I urge all members to do the same. Thank you, Mr. Speaker.